Audio Jungle.
Good morning and welcome to another Labournet webinar. Thanks so much for tuning in. As always, my name is Yasser Ismail, here to make sure that things run as smoothly as they possibly can. As you know, this is a live and interactive session, although if you are watching the recording instead, please don't go looking for the Q&A. As you can see, our topic of discussion is the POPI and PAIA Masterclass, or rather not a discussion, but that's what we're going to be training you on today. And of course, we have none other than Samantha Walker, who will be taking us through today's presentation and session. But before I hand over to her, a quick few house rules that we'll be going through. Like I said, this is a live and interactive session, so you do have access to unmuting your mic. However, we do urge you to please ensure that your mic stays muted while Samantha is presenting. And then, of course, she will let you know when there is specified Q&A times when you can possibly raise your hand. And then, of course, Samantha will answer those questions live. Alternatively, there is a specified Q&A section where you can post your questions. We do urge you to please use the Q&A section and not the chat function for your questions. The Q&A section obviously allows us to field your questions a lot better. It ensures that we don't miss any questions, and of course, it's a lot easier to respond to them as well. However, if you are having any technical issues, you can pop that in the chat function. I will be making an announcement in the Q&A section to let you know where that is. In the event that you do have questions, please make sure that you post your questions as a new question and not as a response to my announcement, and not as a response to any other questions that have been posted. Please note, I know we get a lot of questions during the session, but please note that this session is being recorded. So you won't need to worry about asking us about the recording. It will be made available to you a little bit later on today. We'll post that in the chat section. You will receive a link. Please don't panic if you can't access the recording immediately after the session has ended. We do need to change a few access settings on our side before you can access that recording. So without further ado, I'll be handing over to Samantha Walker to get today's show on the road. Thanks for tuning in. Sam, the floor is yours.
Thank you so much, Yasser, and thank you everyone for joining us this morning for a POPI and PAIA Masterclass. I see we have a smaller group with us, which is actually great because there is more space for interaction. So, as Yasser said, we are going to be handling the POPI and PAIA Masterclass today and really looking at how we can utilize compliance as a competitive advantage. So what we are going to go through, we've got 60 minutes together. The topics we're going to cover is POPI and PAIA. I would like the session to be very interactive. At any point in time, put your hand up. I'll stop. Let's engage in the questions, because those practical questions often help others understand what we are discussing. So we're going to welcome and set the scene. We're going to discuss POPI as the business reality. We're going to go into PAIA and your obligations in terms of PAIA, which is the hot topic at the moment because we've got our PAIA submissions due. The risk that sits on your desk, so real scenarios, tips and tricks we can give you, and then we can go into a further Q&A if there's anything else that we want to discuss. And what I'm going to leave you guys with is a practical 90-day compliance action plan that you can start this week. My little bit of a caveat is we only have an hour. POPI and PAIA are quite complicated acts, but I'm going to try to break it down for you guys so you have exactly what information you need and you can actually practically implement this in your organizations. Before I jump in, though, just a big thank you to KZN Top Business for having me again. I've done a previous masterclass with them, but really appreciate you guys inviting me back for another round. So let's set the scene of POPI and PAIA in South Africa. So the information regulator is the governing body for POPI and PAIA. PAIA used to be under the South African Human Rights Commission. It was moved into the regulator when they were enacted and came into play. Now they are active, they are resourced, and they are watching. The resourced, we know this because they try to poach some of our people to come and work for them, but they really if you watch them on LinkedIn or Facebook, things like this, you will see how many vacancies they've actually put out and how many they're filling. So they really are gearing up for the 2026 year. If we look at historically what has happened with them, there has been over 1,600 complaints that has been filed against different organizations and individuals for POPI. Out of that, we've had 60 enforcement notices. Now, what this really means is the information regulator will come in, do an investigation, whether it's from a complaint or they see something that they want to come and investigate, they will investigate you. They then give you an opportunity to correct whatever is wrong. You have about 30 days. They'll give you remedial actions to do. For example, with the Department of Justice, when they were fined, they were given an opportunity to put in place antivirus software. They had to discipline the individual who didn't put the antivirus software in place, and they had to do some training. They completely ignored the information regulator. What then happened is an enforcement notice was issued with that fine. So the enforcement notice is really when they've given an opportunity to correct and nothing has happened, or you can't correct it, really. They've found a lot of malice or something like that. So an enforcement notice is really where the fine comes into play. The maximum penalty allowed in terms of the Act is 10 million Rand. We haven't seen any 10 million Rand fines, though. I must be honest, the highest one we've seen is 5 million to the Department of Education, and that was over publishing the matric results in the newspaper. They did go to court on that, and the information regulator did win that. So they are active, they know what they're talking about. And they are actively handing out fines as well. We've seen some fines to smaller organizations, such as I believe it was Ram Consulting for the marketing, and they were issued a 250,000 Rand fine for direct marketing that they weren't doing correctly. But I think for me, more importantly than the fines, the fines are few and far between at the moment. I do think they will increase, but I think our biggest risk that's facing our companies today is the public visibility of our compliance. CIPC and the information regulator has paid up. So when you register your information officer on our portal, it actually pulls the information from CIPC with your organization. So they are interlinked. And now on CIPC, you can actually see your compliance status in terms of your information officer, as well as your PAIA submissions throughout the years. So it's quite nicely there. You will see it in red. There's no registration, and there is no PAIA submissions. You cannot catch up a PAIA submission. PAIA is a different act to POPI. We will get to that, but you can't catch up these compliance issues, and then they will be visible on CIPC forever. Someone actually asked me, so how do I get rid of this? I think at this point, the only possible way is you would have to deregister that entity and register a new entity with the CIPC records. So because it is always visible. The PAIA deadline that we are faced now is the 30th of June. That's what we're going to mostly talk about. A prerequisite to that is really you have to do your information officer registration before you can submit your PAIA. So often that's a blocker for companies when they do try submit. And then again, just a reminder on the public visibility. So this act, these acts that we're talking about, POPI at least only was enacted in 2020, but PAIA has been in play for a long time. And a lot of people started putting PAIA manuals in place in 2015 and 2016 when the act came out. But PAIA wasn't really until the POPI Act came out to be its sister act. We had that grace period, which ended in 2021, where we all needed to be compliant. And in 2023, we saw that first major fine, which is the 5 million Rand to the Education Department. And now in 2024, well, 2024 moving into 2025, they had their partnership with the CIPC, and that you can actually visibly see the compliance. And where this is coming from is they don't believe South African organizations are moving quick enough in terms of their compliance. So they want to put some extra pressure here, especially considering, banks, tenders, all of these sort of things get a due diligence process where they go and check you out on CIPC. I know a lot of my clients now are unable to tender unless they have their RO registration certificate, a POPI policy, and their PAIA manual in place. They won't even allow them to tender. So it's almost this is going to become a prerequisite for business. And I do think there's a big competitive advantage if you do this properly. So that's the scene. Let's talk about POPI. Okay, so POPI is the the Protection of Personal Information Act. And POPI tells us how we protect personal information. where PAIA is the Promotion of Access to Information Act, and that tells us when we can give access to information. So they may seem like they are contradicting each other, but they actually fit together quite nicely, because POPI defines what personal information is, how we protect, and then PAIA speaks about general information sharing, not just personal information, for example. So these are our 8 conditions of POPI, and they really are the pillars that we implement compliance with. There are obligations under each of these conditions, but I'm going to go through each of them a little bit of a high level with some insights, and then we can take it deeper into the areas that I'd like to focus on today. So first, accountability. Under this pillar, it's really enforcing who is going to be responsible and accountable for any breaches and things like this, any fines, who should be protecting the information. And condition 1 sets it out quite clearly. The responsible party will always be responsible. And I think they try to hammer this idea home by calling them the responsible party. If we look to the GDPR, they use different terminology to name a responsible party. And a responsible party is anyone who controls the mandate of that information. So at Labournet, for example, if you sign up with us as a client, you give us your information when we're signing the contract, for example. We are the responsible party. We have to protect your information. Okay. You do get what is also known as an operator, or the GDPR calls it a data controller, and a data processor. Data controller is a responsible party. And really, what an operator is an organization or an individual that processes personal information on your behalf. So Labournet, our payroll division, is an operator through and through. We process your employees' banking information and salary information in order to pay them. It is without the personal information, we wouldn't be able to perform our duty. And that's really how you know we're an operator instead of just a service provider like a cleaning company who you're not sharing personal information with. You may have some, but it's not their main purpose is to process the personal information. And really why there's this distinction is because you cannot subcontract your way out of your obligations. So even if you utilize an operator, you are still responsible. Operator's got its own obligations, but you are responsible for that information, for putting the operator under certain contractual obligations and ensuring the information is protected and meeting the standards. Also, if that operator breaches your personal information, you have to report the data breach to the information regulator, not the operator. So really this ideology, it's us as the responsible party. We cannot contract out of things like this. Our second condition, which is probably the most utilized for day-to-day assessing of how POPI works, is process limitation. Now, the process limitation condition has a few sections underneath it, but it's really about when can we process personal information. When I use the word process, it is defined quite nicely in the Act to include pretty much anything you could do with personal information. I always think of processing in the life cycle. It makes it a little bit easier. So when you collect, use, store, or delete the personal information, anything you're doing in that cycle will qualify as processing. I must be honest, I've tried to be a bit cheeky with that definition and try to find an activity that I would do with PI that doesn't fit in processing, and I haven't managed to for the last 5 years. So they've really done a good job of catch all there. And what Section 11 specifically under Condition 2 stipulates is that you can process personal information if you have consent is the first and easiest one to process that information, but consent is not the only way. You can also process information for one of the justifications listed in Section 11. And these justifications are things like we've got a contract in place. So I have an employee. I don't need their consent to pay them and process their banking details because of the contractual obligations I have as an employer. I have to do that. You know, they may get an additional layer of consent for how we process the payroll. For example, if our payroll was processed outside of the country, they would have to get consent to send my information outside of the country. But anything in South Africa, you can process for a contract. Also, if there is a legal obligation to do so. An example here is sometimes my clients say to me, well, the Department of Labour is here for an inspection and I'm not handing over contracts or any information because of POPI. you will get a fine from the Department of Labour because there's a legal obligation on you to actually hand over that information. So what will happen with POPI is POPI will step back to other legislation when there's a legal obligation. POPI also, when there's two specific data protection clauses, maybe in POPI and in another act, for example, the prevailing clause will be whichever provides more protection for the data subject or the individual who. A law, a contract, or consent are your main ways that you can do this. You can do it for a legitimate interest, but legitimate interest hasn't been defined in terms of POPI. It has been defined in terms of the GDPR, European legislation. And if we look at their court cases, they've actually determined a two-prong step test to determine whether it is a legitimate interest. My advice is be very cautious of using legitimate interest. It really needs to meet that two-prong test. And I think between contracts, legislation, and consent, we can cover what we need to actually within our agreements. Purpose specification is really about collecting personal information for a defined purpose. So it must be, your consent must be specific, informed, and a intention of will. So there has to be an outward act in order for there to be consent with POPI. You cannot take silence as consent here. And I must know specifically what I'm consenting to. So we collect your personal information for business purposes. That's not sufficient. But you can tell me, for example, in our employment contracts, what I generally put in for employees is we'll process your information for performance management, training, payment, all the activities around it. But they must be specific. If I'm sending my employees information, IDs, maybe a medical file, if we were in the OHS industry, for tenders and stuff like that, I need to have consent from my employees, and they need to specifically know that is what we're going to use it for. Another one is photos. If we can just use our employees' photos on our websites and things like this, get consent for it. It must be specific that it's a photo. Tell people what you're going to do with their data and why you have it. Also under here, we cannot collect more information that is necessary. A nice example that I always use is if Builders Warehouse, when I was applying for a Builders Warehouse account, they asked me what my sexual orientation was. That would be going too far. Unless Builders Warehouse was going to run some sort of gay pride or something along those lines, why would they have that information? And really, it's as simple as asking yourself why. I know when we put together forms, we put these big forms with all the data on because we want everything. Unless you're going to use it for a specific purpose, remove it. You don't need as much information as you think. And information is actually dangerous because the moment you have lots of information, that's when the hackers start looking at you. And it may not be that your information is important to them, but it's important to you. And that's what they'll take advantage of. Condition number 4 is further processing. And really what this speaks to is once I have the information, I've gotten consent to use, or I'm using a justification for it, can I use this information for a different purpose? And the answer is, well, it depends. Typical lawyer answer. And it's really going to be how closely connected is the original purpose and the further processing purpose. If they are very much aligned, you would be able to further process. If they are very different, that's going to be a problem. So I got consent from my employees to pay them. But now I'm actually going to publish their performance scores, their salaries, all of this on an international website with their name on it for research purposes. They're so far apart, those reasons, even though they're both sort of career aligned, you wouldn't be able to. So there is actually five factors you do consider there, and it's really how connected are they? How sensitive is the information? What are the risks to the data subject in there? So further processing, you can further process in some instances, but if you set it up correctly, you should have gotten all consent or justifications right in the beginning, so this shouldn't be an issue. I would reserve further processing for those emergency moments where, we all have those moments where we went, whoops, we didn't get this or this. That would be a time to use further processing, but it's to achieve that main goal. Information quality, you have to have information that is updated, accurate, and relevant, okay? The general rule of thumb in the data space with the database is a database degrades at 25% per year. After 4 years, your database is irrelevant. If you think about my recruitment companies that I work with, it's always a fight. They want to hold on CVs longer. But at the end of the day, really after a year, I don't know how accurate a lot of that information is because courses update, employers update, we move. And often we don't think to update certain things like that on our CVs or with individuals holding their information. So we've got to make sure that we're keeping it for a relevant amount of time and we're only collecting what's proper and we keep it up to date. So a nice way of doing this is literally putting in your contract. If your details change, please update them with us. That you've then passed your obligation onto your data subject. It's a reminder. We get it at Labournet quite often from our HR. Then they do a cleanup of our data and they send us a link and we've got to agree, yes, this is up to date. No, this has changed, etc. A big one is that we think to miss is when women get married. I got married last year. I'm still trading under my maiden name, and nothing has really changed at the office yet for me because I haven't got that ID yet to change stuff. Okay, openness is really where like your PAIA manual kicks in here. There's some obligations under here for your PAIA manual, but it's really about transparency, why you collect it, what you collect and what you're going to use it for. Think about a privacy policy really tells you all this information because it's meeting the requirements of section 18, which is your data notification. So you have to tell the data subject when you're collecting the information and things like that. Obviously, you would tell them if you're collecting it directly from them. But if you were collecting from another source, you would also have this obligation to inform them. And then I think the one that causes the most policies in our organization is number 7, which is security safeguards. Here, POPI speaks about protecting the information from destruction, loss, unauthorized access. And I think that loss is also quite a cool thing to know because that's why we put in place like a backup and restore policy, for example, because the Act even requires us not to lose the information because it sees the information as so important. So here we generally put your organizational policies in place as well as your technical policies. So organizational policies is really behavioral stuff, having a clean desk, not having information lying here of employees' salaries that people can come in and out of my office, for example. And then your technical policies like what is your minimum access policy? Do you have a password policy for your devices? And all of those types of things. So we really need to protect that data there. And then finally, we have data subjects' rights. A data subject has a right to participate in who has the information and what is done with it. So here, a data subject could come to you and say, hi, I want to know what you know about me. Obviously, we would just verify, is that person with IDs and stuff like that? And then we would actually let them know. We have to let them know it's their right. They then have an opportunity to either correct that information if it's wrong, update it, or request us to delete it in its entirety. Okay, so that's a bit of an overview of the 8 conditions. There's a few additional obligations I'd just like to mention, which is the cross-border. As I said, if you're sending information overseas, it's got to have the same level of protection and you need consent, which is the safest way. There's some justifications, but I think for overseas, consent is the best bet depending on where you're sending it. And the other one is just marketing. If we contact a data subject, so like a cold call, we can only contact them once. If they say no, we can never contact them again. Okay, so just those 2 are to look out for, and really I could get into a whole session just on marketing or that cross-border, but let's touch on this for now. So as I mentioned, this I think is the biggest risk at the moment. I've been preaching about reputational risk with POPI for some years now, and I don't think many people believed me until fines started happening and these big media things started happening. We had the Dis-Chem had a breach, and it wasn't even them. It was the operator, the third party who had the breach, but it flew back on them, and it did have quite a bit of reputational damage for them. I think that's my biggest trick. And even with Labournet, obviously, running this division that I do, and also having to look after Labournet's compliance. We've got an incredible compliance team behind us, but this is what matters, because if anything goes wrong, imagine if our payroll information was leaked or hacked or something like that, no one would trust us ever again. And that's why we've got to maintain meticulous standards, and we've got very, very high safety standards because we do consult on this as well. So this Biz portal, what can you see on there? As I mentioned, it's your RO registration and your PAIA submission. So bankers see this, tender panels see this, competitors see this, the regulator sees this. I often go and check my competitors to see who's registering and who's doing what. It's a nice thing to see whether they are as concerned about compliance. You can go look at your competitors' PIA manuals and privacy policies, and all of this stuff is now visible to you, and you can see whether they are my English is running out. I want to say whether they're orbit, whether they're on it with your compliance, with their compliance. And this is really where the competitive advantage starts coming in. The generations that have been raised with digitization and technology, they expect more from companies. They want to know where the information is. This isn't my mom just clicking yes, yes, yes on every Facebook ad that comes up. These guys know what's happening with their data. They understand tech, and they really demand high levels of protection from us. So, as I mentioned, you have to register your information officer if you have not. Please go on to the Information Regulator's website. They do have an e-services portal there that you can click on. Register your information officer with your company details. If you do not do this, you can't do your PIA submissions. So I would get this sorted now, because maybe there's an issue. We have had issues in the past where it's pulling through wrong information from CRPC and we need to log tickets and stuff. So I do suggest that ASAP. Make sure you have a PIA manual. Okay, the PIA manual tells individuals how to actually go out and request information from you, and what records you hold, what records are immediately available, or what records do I need to put a PIA request in place for. The Information Regulator does have a template for the PIA manual on their website. I think it is a bit thin, but again, utilize everyone around you. Go check their websites and their PIA manuals and see what they are doing. Annual returns. You got to obviously do your annual returns with CRPC, because it does trigger that deregistration risk. And the reason I point this out is they are busy going through companies at a massive rate with CRPC. There's actually about 500,000 companies that are at risk of final deregistration. They'll never exist again. And starting to flag because of annual returns, IO registrations, and PIA manuals. So when you don't have that compliance level, they coming and they're actually starting to look further. So it is what we normally call a radar risk. You know, hide the big things first. Make sure your PIA manual's on your websites, and that's the easiest way for me to see whether you're taking your compliance seriously or not. Have your POPI policies in place. There is enforcement notices, so implement now. Data breach plan. Please have a plan if you have a data breach. A data breach is not a planned thing. They come out of anywhere. Our employees can click on a phishing link. We can get hacked. Someone can break into the building and steal our servers. If we remember the looting in Durban a couple of years ago, we had to report all of those laptops with data breaches. And it's in that moment that you wish you had a password on that device, that you wish you did this, that you wish you did that. So everything that you wish when you're in an emergency situation, put in place now. And that is going to be your competitive advantage, is that you're prepared for anything that happens. We are becoming the hacking hotspot of the world, and that's because we are slow to adopt cybersecurity and data protection measures. And it's becoming easy. And as I mentioned, I keep hearing, oh, my data is not important. No one cares. No, you care. So they will encrypt you out of it. I once had a prospect that I was dealing with in Nelspruit, and they told me that my 1,000 Rand retainer was a bit much. You know, they don't think it was that necessary. About 3 weeks later, they were hacked, and the quote we got them to unencrypt their data was over R1 million. And this really could have been prevented by some firewalls and a couple of security features in their Azure environment. So we must be keenly aware of this. POPI is not a one-man job. IT must be involved, HR must be involved, marketing must be involved. And that's why in a lot of our bigger clients, we actually set up a POPI committee with representation from all of these individuals to make sure everything is covered. Okay. And then please train your staff. They are your front line of defense. If the Information Regulator comes and audits you, we've had them audit a few of our clients, they actually walk to different employees and ask them about policies, about certain data protection requirements. And if they can't answer, they are going to fail that, and it's really because POPI requires a behavior change. Me not keeping personal information on my desk is a behavior change. Me logging in with a password or multi-factor authentication, yes, the tech is there, but you have to manage the behavior change to the tech. We've seen companies bring in $1 million systems and the staff won't utilize it because there was no change of behavior management towards the system. So they need to know their rights. If your staff knows their rights in terms of POPI, they will know your clients and everyone else's rights. And then you lock that framework in, and you ensure that you almost build this culture of privacy. It must become a hot topic. We utilize Momcast for our security training here at Labournet, and when different team members watch these videos, they try and make them quite entertaining. And we always hear people at the coffee station having a giggle and discussing that. And the collaboration that happens is, yeah, I also was sending emails without a password protection, but now I'm going to enter. So those small little tweaks and changes to really enforce a culture of privacy, because that's ultimately what you're going to need. Okay, so PAIA. What the law requires from your business. So what is PAIA? I've touched on it, this Promotion of Access to Information Act that gives anyone the right to request information held by your business. Now, there's two kinds of businesses we look at under PAIA. We look at a private business, which is a majority of us sitting here, and then you also get public businesses, which is your state-owned entities, things like that. The difference I just want to make here is a private has got certain requirements for their PAIA manual. A public body has more intense requirements. So if you are sitting here from a public body, you need to go and take a look at the further requirements that you would have to impose. The next difference is if a data subject requests information from you, if you're a public company, you have to give it over if it's their information. If you're a private company, you only have to give it over if it can be utilized to exercise a right or enforce a right somehow. So I want your sales commission policy because I was your sales guy and I don't think you paid me correctly after my termination with my commissions. I want that policy to go to the CCMA and fight for my money. That's enforcing a right. There is also other reasons that you deny PAIA request. If there's trade secrets, things like that. I once had a client in the mining industry that's listed on the stock exchange, and we started getting all these funny PAIA requests, and we started realizing they were asking for bits of information from different requesters to put that information together to work out what the company's next big move was so they could play the stock exchange and actually make some money. So it was very ingenious the way they did it. It took us a while to figure out why they were asking for certain information. But luckily, we held off because they weren't quite telling us what right to enforce. And that's how we were able to push back. Now, your PAIA submission that I speak of that is due 30 June is really just about, did you get any PAIA requests? Most companies at this stage and our smaller companies are submitting null PAIA requests. So no, I didn't get any requests. It does go further. If you did have requests, was there an appeal? Did you grant? Did you not grant? Most of my clients are still filing null reports because PAIA is quite new, sort of in, I want to say in the SME space, but the corporates that have had PAIA manuals for a bit longer, they tend to have a few PAIA requests, and we are seeing more and more requests come in. So we're in our reporting season now. We've got about 1,500 clients we report for, and I can see from the forms coming in and the data coming in that we are starting to increase the PAIA requests. And that also happens because the public is now more aware of POPI and PAIA. Before, when people asked me what I did for a living, and I would say I'd implement POPI compliance, they would think I'm talking about flowers. Now they know I'm in data protection. So yeah, I think the media has done an outstanding job in really raising that awareness, not always correctly, but getting the message out there. And the information regulator has done so as well. They've got a lot of webinars and stuff you can attend, and open days and question days, and they've really have made themselves open to us. Common mistakes that I see with this: submitting a manual that does not reflect your actual business operation. So as I said, go still with your eyes, go look at your competitors, who's doing what with their manuals, but don't just take someone's manual. Firstly, it's plagiarism, but you will get in trouble if it doesn't actually reflect your stuff correctly. In this manual, it tells them like what records you actually hold of like what legislation. So you would say, we hold records in terms of OHS, the Labour Relations Act, Basic Conditions of Employment, or whatever it is. And if that's not accurate to your industry, you're going to have some issues. So that list changes quite a bit per industry. I'm sure you can imagine a mining client and a beauty salon has very different acts they've got to deal with. Okay, so do not use that generic template. Again, I'm going to say, if your IO is not registered, you haven't bought your ticket to the game, and then using the wrong portal. So try submit on the e-services portal. You can do some stuff through Biz Portal, through CIPC. I am a little bit worried because sometimes it doesn't quite pull through. So I would advise do it on the e-services portal. And there I've just got a little section on what must be included in your manual. So the contact details of your information officer. Do not put their personal cell phones and emails out there for the public, because this is on public. It can be trawled, information can be pulled. I would advise setting up like an email address like POPI at Labournet or PAIA at Labournet like we have, and allow the contact to go through there. All your categories of records held, as I said, the purpose of processing. So why do we have this information? The types of data subjects they have. So they have employees, clients, suppliers, etc. And then the Section 10 guide reference, which was published by the South African Human Rights Commission. You also need to have the PAIA guides in at least 2 official languages. It is on the Information Regulators website. They are in all of the official languages besides Braille. I'm not sure. They did discuss that they are planning to do something with it, and I think they are looking at some form of technology with it, whether it can read to you or things like this. Deadline 30 June. Please check that your IO is registered. Last time I'll say it, I promised, maybe a few more times. But I see this is where tragedy strikes. They're so ready to submit, and now we miss deadlines because the CIPC information wasn't correct or something. Just a hint, your CIPC documents, copy that exactly into the portal when you are registering. If there's a spelling mistake there, carry the spelling mistake, because otherwise you will be kicked out. So it's things like this that I'm always so worried about. My anxiety tells me register now. Okay. I see this has jumped to a funny size, but that's okay. What looks good? What does good look like? So there's about 11 sections throughout this that you would have to go into with the categories, how we process, what personal information, etc. As I mentioned, there is a template on the Information Regulators website where they do explain how it must be, but go take a look at, it's quite nice to just Google X PAIA manual. If you want, like, go take a look at Laburnet's PAIA manual, and you can see what it looks like. So it is quite a detailed document. Our registration prerequisite, sorry, I lied. I'm going to say it a few more times. You have to submit on the e-services portal by the 30th of June. Now, in terms of a public body, they're looking at a Section 34 manual. And then in terms of a private body, we look at a Section 51 manual. And it's just, they're almost identical. As I said, the Section 34 manuals just have a few extra sections for the public bodies. But postal and street address, contact details of RO and Deputy Information Officer. As I mentioned, that Section 10 guide, any records available, and categories held. Your manual must be updated annually. It's got to be on your website as well as available at your front desk or reception area. If your business changes, your manual must change with it. This is why POPI and PAIA aren't a once-off, but is a continuous journey. The risk on your desk right now. Okay, so I've said that these are not hypothetical because these are current situations that we are dealing with, but I'm going to use them as scenarios that really play out that we see quite often. The data breach you did not report. Okay. So a payroll clerk emails salary slips to the wrong distribution list or mailing list. 200 employees' banking details and ID numbers are exposed. The legislation says you have to report this data breach. But now, importantly, Section 22 says you must report a data breach or a suspected data breach. So there's no more of that ignorance is bliss. They've caught us with that, even if we think we've got a report. So the issue also comes into play is the information regulator. It's not legislated, but they want you to submit within 72 hours. It's on their website and in their codes of conduct. And what tends to happen is 72 hours runs quick. When you learn there's a data breach, most likely the first time it happens, the first day will be a panic day. That's why I recommend having a proper data breach response plan in place. So when the panic hits, we start following processes instead of panicking. This kind of a data breach is massive. We are seeing it all the time. If it is possible, try cut email out of your business as much as possible for internal stuff. We're often using things like Microsoft. So we've got Teams. There is safer methodology out there than emails. Email is really risky and can be intercepted. So, for example, in my team, we have a rule: we're not allowed to email anything. We have to utilize our team folders or Teams chat if it's something urgent. But otherwise, the habits I'm building into my people is to log onto the platform, go there, retrieve, put it there for someone else to retrieve. So nothing exists outside of that ecosystem. Yeah. Clicking on emails by mistake, wrong person in emails, the wrong Samantha. We see it all the time. Be careful, watch that sort of stuff. But there is Microsoft. If you're on a Microsoft business like we are, there is security requirements that you can put on to help your people, where it says there's people outside of your organization in this mail, things like that, which does help. I'm sure we've all been through one of those moments where we've replied to our colleagues being like, what is going on here? And then you realize the client is CC'd in that mail. So it is very helpful for a lot of those type of things. Number two, the tender you lost. A construction company bids on a 15 million rand government tender. The evaluation panel searched BizPortal. No I registered, no PAIA manual submitted. The application was disqualified. They didn't even decline it. They sent them back the disqualification. You're disqualified because you are not compliant. So that is starting to happen more and more. And I know the proud guys like Woolies, for example, puts their suppliers through a hell of a service provider security vetting. I have gotten a few of my clients compliant for that process. Massmart does it. A number of these big players have developed their own. For example, if you're going to onboard with Labournet as a service provider, particularly in the tech space, it's very intense, that onboarding that we go through, and that's to make sure we are safe because of the payroll data we sit on, as well as the labor law information and those HR records. And the third, the employees who knows their rights. As I mentioned earlier, an employee who knows their rights knows everyone else's rights. I think it's just human nature, and this is some little psychology trick. I've found training staff, particularly frontline staff, your receptionists, things like that, if they understand how it works for them, they will be able to explain it for others. So I see a lot of companies push this training on their frontline staff. That's like data subjects, responsible party operators. These are very scary words. They don't know the legislation. It's a new lingo and all of this. But if you tell them you have the right to your information being protected, would you like someone leaving your information on the reception desk? They're going to say no, and it's so much easier to get them to understand that. So really train from a personal perspective with your frontline staff. And here, an employee submits a PAIA request for all personal information you hold on them. You have 30 days to answer that request. If your records are scattered across emails, shared drives, and paper files, you're going to battle to respond to that. The worst is that when we have key individuals on leave and we cannot access certain things. Yes, we've got 30 days to respond, and we can request an extension from the data subject. But if they say no, we've got to stick to our 30 days. Okay. And failure to respond within 30 days is actually a criminal offense with a fine. POPI and PAIA have both brought criminal offenses back into civil legislation. But if we look at what the fines are for, it's really for, and the criminal sanctions, it's not new stuff. So I don't want to cause some panic and think everyone's being arrested. No, a lot of those criminal sanctions is for fraud or creating a false document. Those were all normal crimes before POPI. They've just made it very explicit and actually given details of how it will be handled. So yeah, make sure you've got processes in place as well to meet your 30-day deadline with your PAIA requests. And now your 90-day compliance plan. So week 1 to 2, I want you all to register your information officer with the IR. Now, who are you going to register? You're going to register the head of your body. So your CEO, your managing director. I'll get a little caveat here. Your CEO and your managing director are generally too busy to fulfill this function as well. But whoever sort of sits with your finance or your IT functions, I find works very well. The finance guys handle this really, really well. And I think it's because Psycha, the accounting organization, has really trained them a lot. They have to log into Psycha to get updates on data protection and things like that. So they tend to take it a lot more in their stride. If you do have a finance person, for example, with us here at Labournet, our CEO there's no way this could have landed on his plate. He's far too busy for this, being with all of us execs. So it is with our CFO, for example, and it's run so well. He's got compliance underneath him, and I think the finance people really just understand regulation because they're so used to regulation coming at them in their industry. So I do suggest a little hint there is try get a finance person. We generally find quite a bit of luck with them. And even if you don't register your information officer, they are still responsible. I hear this quite a bit, that they say, well, if I don't register, they can't find me. You are the head of that body and the information officer, whether you register or not. If you don't register, there's just worse consequences. You're just making it worse for yourself. Week 2 to 4, let's compile or update your Section 32 or your Section 54 PAIA manual, depending. And then in May, let's submit that PAIA manual via the RR services portal, and you would then do your PAIA submission by June. And then I would start implementing any POPI policies and staff training breach response plan going forward. This is not a once-off thing, POPI and PAIA. This is really a continuous journey, and that's why we offer the subscriptions that we do. I don't offer once-off products to put this in place. Particularly around this PAIA time, I'm getting a lot of emails by saying, no, but I got quoted this once-off of this. I cannot ethically allow that to happen with my clients. I think I refuse, because I know you're going to walk away from me and things are going to have changed, and then you're going to need assistance without having that assistance. I used to implement once-off packages when I was at Snyman Attorneys, and every one of those clients I implemented are actually one of our clients now at Labournet, because their compliance was non-compliant within 6 months of me putting that in place, because of the updates on PAIA and the PAIA forms, as well as just the code of conducts that have come out. So I think particularly now, we're in a space where this act is moving, it's growing, it's changing. We've just had the medical code of conduct now being dropped in March. That's so fascinating and interesting to sink your teeth into. So, and they're going to go by industry, and we will get more information, but that's why it must be an ongoing journey. Hackers get better every single day. They come up with new methodologies. Back in the day, I think remember when I was little and we had dial-up modems and stuff like that, the biggest fear was this Trojan horse virus that could come in. And I remember that so specifically from when I was younger. And let me tell you, the Trojan is still there. He's just changed forms many, many times over. And it's not only just trying to brute force your systems, they social engineer us. Often we get fake emails from clients and things like that, because they know they can see me interacting with that individual on LinkedIn and see there's a relationship. So they also utilize that for the social engineering to figure out your passwords, figure out who to email, figure out how to phish, and all of that. So I really do believe in an ongoing process, because things are changing too quickly. Hackers are getting very smart. And thirdly, we're becoming the hacking hotspot of the world. If I think we are already, to be very honest, and it's something to be concerned about, because you don't kind of want these guys targeting your country. But to sort of give you information about where we are seeing attacks come from, it's very much a lot of Eastern Europe, from Ukraine and things like that. But interesting, we are starting to see a rise in attacks on South Africa from the Americas, from your North and your South America, and it's not slowing down. The stats just increase and increase and increase. So I really can't suggest enough to make sure that you have your security requirements in place. I think the worst thing would be to lose your business because of reputational harm, because of one of these compliance things. We put our life and our souls into our business. And yeah, that's why I'm very intense about Laburnet's data protection compliance, because I've put my heart and soul into this business and my business that I've built. And yeah, if there's anything I can leave you with is care about this. It does matter. People care about where their data is. I've moved service providers. A lot of people I know have moved service providers, and we're starting to see a lot of disciplinary actions and dismissals around it. So take it seriously. You won't regret it. Your clients will respect you for it. And if you do need help, you can go to our labournet.com at our PAIA submissions page. You are also welcome to reach out to us at PAIA at Labournet or POPI at Labournet. They both work, and we can actually assist you guys with your compliance if you would like. Otherwise, we're more than happy to do a free gap assessment for you, give you some pointers, and help you on your way. I just want to see now if I have any questions.
Sam, it looks like there are no questions in the Q&A section or the chat function. I'm just going to refresh mine just to make sure that I'm not missing anything. But no, it doesn't seem like there's any questions. So thank you very much for your time, as always, for your expertise, and to our attendees, as always, you do know that this is being recorded, and we will be sharing the link in the chat function in the event that you need to watch it later on.
Awesome. Well, thank you everyone for joining us. Please, if you do have any questions that you didn't want to ask now because of the recording, please feel free to reach out at POPI at Labournet or PAIA at Labournet, and I will get back to you. But thank you for joining me. I hope I imparted a little bit of my passion and have inspired you to go put data protection in your businesses. And yeah, look out. We often do a lot of these webinars and educational things via Labournet. It's one of my favorite things to do. So you are welcome to watch our website and sign up for any of our future webinars. Awesome. Have a lovely week further, everyone.